the public school arena. If a public school says, yes, we're going to allow an atheist group, say, to meet on campus, then they have to allow all sorts of other groups as well, right?
That's exactly right. I mean, in the public school context, you're talking about the Federal Equal Access Act and the First Amendment, which protects free speech and the free exercise of religion, which are these important principles that we're debating. And that's the idea. The government has to be neutral with regard to religion. So the government can't show any favoritism towards religious groups or viewpoints, but they can't show hostility either. And if they block out the Christian group or the religious organization just because they have that particular viewpoint, then they violated important principles of federal and state law, and that's what we have here.
That'd be the same as, say, a public school renting an auditorium. If they rented it to an atheist group and said they weren't going to rent it to a Christian group, then they'd be in trouble with the law, correct?
They would be, and we win those cases all the time because, again, it's very well established in federal court precedent and the interpretation of the Constitution that you can't do that. You have to treat religion with the same dignity as everyone else. And just because an organization or an applicant happens to have a religious viewpoint, they can't be treated as second-class citizens, and that's an important principle.